And it's 3 minutes after the hour, so we're going to go ahead and get started. This is Andrew Brust from Io-Tahoe. I want to welcome everyone to our Tuesday webinar. And this particular Tuesday webinar, we're talking about a very important topic in the world of data and analytics and data governance, and that is GDPR, the European Union's General Data Protection Regulation. And we want to talk specifically this week about how European companies have moved towards compliance. My guest this particular webinar is Tiberiu Covaci, and I'll say a few things about Tibi, but I'm going to ask him to chime in as well, since he knows his own background a little bit better than I do. But Tibi is a seasoned tech lead in all sorts of European markets. I think if I have it right, Tibi, you're from Romania originally. There we go, and that means I can hear you too. You're stationed in the Canary Islands now. I think you did a stint in boy, was it Sweden, if I have that part right? And we know each other through the Microsoft Regional Director Program. You've also been very focused on cloud computing of late and working with a couple of major European clients in that arena. So that's my 5-cent little introduction, but maybe you have a little bit to add.
So yeah, as you said, I've been around in Europe in many countries, which gave me quite an interesting experience, to see how other countries are, or how companies in different countries are working, at least around Europe. So I've been in Sweden, as you mentioned. I've been living in UK for a while. I've been doing work in Romania as well. I've been doing work in Spain for the past 2 years. So Canary Islands actually is based it's part of Spain. Plus that I've been living in Bermuda. That it's another paradise island that they have quite different regulations when it comes to data and privacy and all those kind of things.
Yeah, Bermuda's a little bit different, especially for financial companies and what kinds of regulatory burdens they have there. But so now you're on the Canary Islands. You only seem to want to live in beautiful places. And while that's part of Spain, I guess geographically you're off the coast of West Africa. Do I have that right?
That is correct, yes.
All right, very good. My name's Andrew Brust, and those who have attended these webinars before may already be familiar with my voice. I advise Io-Tahoe on market strategy and product strategy. I write about big data for ZDNet and have been doing that for several years. And once upon a time, I was a developer and a database specialist, and that goes way back actually to the mid-'80s. A lot has changed about databases, certainly in that time, and especially a lot has changed about the economics of databases and how much data we're able to store and analyze. The economic viability of that has changed a lot. That means we're able to keep a lot more, but that also creates a much greater surface area, if you will, for a much greater surface area for things that need to be protected and for privacy potentially to be exposed. And that's really what GDPR is all about. It's about ensuring customers' privacy in an age when all kinds of data is being kept longer and leveraged more and analyzed more. All of that's positive, but there may be some downsides if we don't manage things properly. So we want to talk a little bit about first what GDPR is, and we probably won't be able to define it comprehensively as it's a pretty long set of regulations, but hopefully at a high level we can get a sense for what's involved, and then talk a little bit about how readiness is being approached. At Io-Tahoe, we're actually based in New York, although we have a development team in Europe. But a lot of the GDPR discussions we have been from the U.S. perspective, because U.S. companies are impacted as well. Any company with customers in the European Union have responsibility here. But we want to hear how European companies, the people who are directly in the jurisdiction of the EU, how those companies are handling it. So I'll kind of forward into our first slide if I can, and let's just kind of talk about the fact that in general, I mean, as the name would tell you, GDPR is about protecting. It's about protecting data in general, but it's very focused on sensitive data or personally identifiable data, PI or sometimes PII for personally identifiable information. You see on the left side of this slide that there are some hefty penalties for non-compliance. The larger of 20 million euros or 4% of the company's global revenue. In some countries, you can replace the word revenue with turnover. It means the same thing, but different terms are more prevalent in different countries, so I'll just mention those two go together. It takes effect on May 25th of this year, and given that today's already February 13th, we're starting to get pretty close. Now, there's some other points on this slide that we could speak to, but Tibi, maybe generally you could maybe give us a sense of how your clients see GDPR at a high level in terms of defining it.
So actually for most of the European countries that's nothing new. So that's why a lot of people would expect the companies with pitchforks and getting nervous and ready to do stuff about it. They are not too affected, or maybe they, and I don't think it is because they're not taking it too seriously. But at the country levels, a lot of countries had their own regulations. Like there's already a law in Sweden that came out about I think about 16 years ago. There is a law in Germany, there is a law in Finland, and many other countries around Europe. Actually, they already have those kind of laws and regulations. And what the GDPR will do now will try to unite them. So that would be the law to rule them all, if you may. If we are a bit geeky about it. But that's what they, the
mother of all data protection laws.
Exactly, the mother of all data protection laws. So that's where that's what actually they want to do, because you might find yourself doing and being a successful business owner in country X within the EU, and then all of a sudden you're breaking the law, although you are not doing anything different because you do stuff in another country. So because data now and we are living in an information age, it had to be done. So that's why we get there. And of course, they want everything to be taken seriously. That's why they have the hefty penalties. And I think that's what most people are talking about. Oh, GDPR is coming. That means a lot of money we'll have to pay if we are not complying. But I think at the same time, there is a little bit of confusion because many people don't know what exactly would it mean, like what do we need to do at the end of the day.
It's sort of interesting, I think, because I hear, if I read between the lines a little bit, what I'm hearing is within the European context, this is maybe this is less about a new kind of, I don't know, harsh or strict regime, and more about just making things more uniform. And this, I guess, this is a European Union theme in general, right? It's made up of many sovereign states. Of course, sovereign states have their own laws, but because there's a single economy, it behooves all the member states to get together and sort of have common law so that companies can more easily do business across those national borders. But of course, again, for those of us in the U.S., it is a vast difference because it didn't impact us before. So not only does this make things uniform across Europe, but it makes things uniform even for companies that are outside of Europe, because now this isn't just about the jurisdiction of an individual country, but rather the entire union. Is that a fair, Tibi, do you think that's a fair interpretation, or am I being a little too liberal there?
No, actually that's more or less what it is. And like any law, that's one of the issues is this one, does not really tell you how to do the things, or it just describes the obligations, as a company, what do you need, you need to do, but now how you comply to it. So that's, That's one of the problems. And they look, like any, like whenever you have to do with laws and jurists, you get, very broad terms like adequate protections or safeguards, like, or technical measures, but it doesn't say anything. It just say that you need to have something in place, and how fit or unfit those turn out to be at the end of the day. It would be, I think, it would be case by case basis at the end of the day.
All right, and so we have now I will get to some of the specifics in the slide here. We have pointed out some important kind of takeaways here, and I'll just mention in total transparency that the Io-Tahoe product excels in assisting with these particular things, which is one of the reasons it's on the slide. But these are important no matter what. You're going to need to do serious data discovery. And data discovery is not, I hesitate with that term because it's used in different contexts. Sometimes data discovery means visual data discovery and visualizing your data and creating dashboards. That's not what we mean here. We kind of mean discovery almost in the legal sense of discovery, where you have most likely, if you're a big enterprise corporation especially if you've done acquisitions and brought in other companies and their systems, you're going to have databases and systems all over the place. And most companies, because these things have grown organically and because different business units within the companies have built different systems, I don't think there's any shame in kind of pointing out that most companies don't have a full comprehensive command over their entire, there's this new term we're starting to use now, data estate. There's a lot to really take inventory of. And there's a lot of relationships between these databases and now especially data sets inside of data lakes and places like cloud storage and Hadoop and Spark, all these distributed file systems where you really need to do discovery to understand everything you've got. Now that can be a manual process or that can be an automated process. And obviously, automation can help if you've got a big, overwhelming backlog of discovery to do. You're also going to have to secure the data. That is super important. Maybe that's the whole fulcrum, really, that we're talking about here. Some columns should not be visible at all to various parties. Others should be, encrypted or partially masked. There is a lot to do in terms of security, and at least in one case, in one industry, I've heard there's even differences in terms of whether that data can even go to the cloud and be moved off premises. Then there's also this thing, and growing up as a developer in the 90s, I kind of learned, Tibi, I don't know if this happened with you too, but I kind of learned that you should never really delete anything. The first systems I wrote, had a delete button, so that if you created some kind of record in error, you could delete it. Then I learned, well, we don't really delete it; we just kind of mark it inactive, but data's never deleted. But actually, in the European Union, there is this notion of the right to be forgotten, the right to be erased, if you will. And so that needs to be in place too. And of course, you can't really delete stuff properly if you don't understand the data flows between systems and where all the copies of things are, especially if you have redundant systems. And that's another thing that may need to take place. You may need to say, all right, you know what? I've got 10 copies of this data, and actually only 3 of them are useful. So I may need to dispose of and sunset 7 of these. Not that that's just something you do, by fiat. You've got to, you've got to really do some planning around that. But that's kind of what we're sketching out on this slide. Are there other pieces, though, Tibi, that maybe you could add that I've overlooked?
Circling back to your point about never deleting data, I think that's one of the things that would, it becomes very important because, like I said, yeah, we are not going to delete the data. Who knows? Maybe we might need it in the future, and then we ended up with, with petabytes of junk, and nobody knows what is actually kept for. Yes, they have the is deleted, or it's still active, flag on, or something like that, or off, or whatever you chose to have inside your application. But now I think with these kind of things, it makes us to, to really actually value the data when we have it. And when the customer says, yeah, I don't want you to have my data anymore, to really make sure that we delete that, because otherwise we'll be liable for that.
And again, I guess there's this whole notion of surface area, right? We're saving more. We've had maybe, what I was describing was sort of a pack rat mentality, like don't delete it, you may need it someday. But the problem with that approach is you may lose track of everything that you have. And then because data breaches do happen, and they happen maybe with more frequency than we'd like, the more surface area you have, the more risk you have. So we want to prevent breaches, but we also want to mitigate the damage that could be caused when breaches occur. And so all of this is important. It really is, it's a paradigm shift in terms of how we think about managing data and what our applications do in terms of what they create and what they retain and so forth. As the slide says here, this is the most important change in data privacy regulations in a couple of decades. So this is a big, big deal. Let's keep continuing with our level set here, and maybe we could define a little bit of vocabulary. Tibi, would you feel comfortable walking us through some of the stuff that we have on the slide here? I've been running my mouth a little more than I intended.
Yeah, no problem. So as the graphic here actually explains, we have different entities that are involved in that, and a data subject is actually a private person. So a data subject won't be another another legal entity that we do business with. It would be actually a person, a private person, and that private person will have interactions with different companies. And those companies would be called data controllers. So one of the examples I'm using, just to make it, relatable with everyone that actually works that, I would say the data controller is Amazon. So as a data subject, for instance, I would need to go in and register to Amazon, give them some of the personal information, your private identifiable information, in order for them to be able to leverage the goods. Now, they have a legal responsibility towards me with regards to my private data. But for them, maybe sometimes they say, oh, you know what, we are actually either hiring a third party to do the job for us, or we are actually working with not necessarily subcontractors, we're working with other entities that will do the deliveries for us, so we are just showing their data. So although I have my relationship as a private person is directly with Amazon, Amazon in its turn would have, relationship with the data processors. So data processors, they do not have a direct responsibility towards me, but they have a responsibility towards Amazon. And in their turn, they might have other sub-processors, so other people that will take the data and work with data. So every one of those three would actually be responsible with regards to GDPR to protect my privacy. So now, if something it's wrong, then I can go after the data controller, and data controller can actually say, you know what, I've done my job. I have here the necessary paper that proves that my data processors were actually guaranteeing me that they are GDPR compliant. Now, it's not my responsibility as a controller to make sure that the data processor is GDPR compliant, more than taking them on their word. But that doesn't mean that I can just relax and then just put every responsibility on someone else, and then I shouldn't care. So again, it should be something that everybody should be really taking these kind of things seriously.
Okay, so there really is a dependency chain here, right? The data processor is relying on the efficacy of the claim that the sub-processors are making, that they are compliant. The controller, in turn, is taking the processor at its word that it is also compliant, and then based on that and its own practices, is vouching to the customer, the data subject, that the controller itself is GDPR compliant too.
Yes.
So there's a lot of cooperation required here. And is it the case that there's really no kind of certifying authority This isn't exactly like you get a certificate that says, yes, you're compliant. Am I right?
That is correct. That is correct. So there are some self-assessment things that you can, every company. I think even Microsoft has a like a self-assessment that you can go through, and that will help you ask the right questions with regards to what you are doing as a company. So you can go through the list and see, okay, am I doing that the right way? What happens if that is happening? Am I doing that and that? So this is a lot. This is a very interesting. Point for to be known, because it makes your life easier if you have something like a self-assessment to go through. But that again, there might be people coming and say to you, "Oh, we are selling certifications, GDPR certifications," or they actually no, they don't do that. They might have they might have an assessment sheet. They might help you go through that and might help you ask the right questions, but they are in no way, approved by anyone, or at least not yet, to make sure that you get the right certification with regards to that. The only thing that comes close to it, it's actually ISO 27001. That's the only thing that might come close to any certification with regards to data privacy, I would say, and security. But that's not really that doesn't mean you are GDPR compliant just because you are an ISO 27001 compliant.
Right. But I guess nothing gives you absolute assurance. There does seem to be a component of the honor system here and trust, which is interesting. Which ISO standard did you say was the applicable one? What was the number?
27001.
27001. Okay. All right, that's good to know. I've now learned something new. But I think we just stepped on something which is really important. That although the responsibilities here are quite serious and the penalties are quite grave, there still is some notion that we kind of have to figure this out as we go along. And that makes it maybe a little scarier, but I think it's also important to realize that everybody's doing that. And a lot of what's really required here is kind of earnest best effort. Let's talk about a little bit more kind of vocabulary to get a sense of who all the entities and parties are that are involved here. So at the data controller, there's going to be a person called a DPO, a data protection officer. And the DPO is, one way to look at it, I suppose, is a compliance officer for GDPR specifically. But that person needs to be independent and needs to have the ear of the highest levels of the company. And that's important, that a lot of companies are going to need to have DPOs. And Tibi, is there kind of a cutoff in terms of revenue or number of employees where a DPO becomes required?
No, there is no such thing, but I think, depending on the size of the company, that might be more than just one-man job at the end of the day. So, if it's a small company, you can do that as a part-time, or you may, several companies may share one, I would say. They may actually hire someone from outside. That it needs actually one of the things that actually is very important in this whole context it's the notion of accountability and governance. So you need to actually you would be held accountable for that. So in order for you to be able to make sure that you do the right thing, you need to have someone that has your best interests at heart. So that's why it's very important to have the data protection officer. It needs to make sure that all the processing activities or what you're doing with the data, it is known, it is recorded. So yes, we get the data from the users, and that's what we are doing them in this particular process. In this particular process, this is the kind of data. And if the data is not of a personal matter, it's not a sensitive data, then you just don't care. But if the data is sensible, then you need to think about that. I think one of the changes that should come into our industry, because we always had the same issue, like security was an afterthought. It was something that came after the fact, like, yes, it is a quality attribute, and whenever we do work or we do something, yes, it is and by the way, it has to be secure. Now I think we need to change a little bit, at least when it comes to applications that would run in the European Union, you need to have a data protection. It should be in the design. It should be by default in there. You should start with that in the very first place. So that's from, that I think that would have to change. And of course, you need to have some, some impact assessments. If something happens, how would you respond to that? How you fix that? What's the risk of happening, and so on. So there are a lot of things that a data processor or the data protection officer has to do. And again, it is a responsibility, but you can't say one person it holds the sole responsibility towards all the things that happens inside a company. But as you say, it has to report to the highest leadership level, because it needs to be a buy-in from the highest, from the highest level, because it can be very costly for a company, and it can even lead, reputation. I think a lot of people do not care about the reputation breaches anymore, because if you look how many data breaches we had lately, the reputation, it's the one thing that they care less. It's more that, all the other discussions, and maybe the what the shareholders are doing, and the fact that you don't have the money to run the business after you have to pay hefty fines and people running away from your company.
Right. So one other note on the DPO is that this person needs to report any breaches that might occur within 72 hours of their occurring. And of course, that's an important reason why that person needs to report directly to the leadership of the company, because if that person were within a business unit and maybe politically that business unit would lose face by reporting the breach, we need to avoid that. And actually, the DPO has legal responsibility and exposure there. If the DPO doesn't report it, the DPO has failed in his or her responsibility. So there's real skin in the game here. There's consequences if the breaches are not reported. So some of the really epic breaches that we've seen lately, where we found out after the fact that it was actually kept secret for the better part of a year, that's not going to happen anymore. Unless you're a company outside of the EU and you have no customers inside of the EU, this is going to bring about a change that's global, not just European.
And the 72
so that's
hours
a big deal.
It's just it's actually it depends on actually the importance of the breach. It can even be 24 hours. There are no, I would say, best practices or whatever you want to call it, or praxis. There is no praxis yet because there is no law yet, and some of the things will have to be implemented a little bit later. Because there are some there are some situations that they need to be they need to be tested in a court of law in order to actually say, okay, where do we draw a line? Where do we think this is? This was you should have done it within 24 hours, or you should have done it in less or in more than 72 hours, or whatever. So there are still things that we need to figure out.
It does seem like the measures of compliance will largely be determined by precedent, and by definition, the precedents haven't been set yet because the law has not come into effect. So we do go into an initial period where, people are going to have to kind of play things by ear a little bit. But I think it's also important to kind of put out the concept here that although this is a formidable responsibility that should not be taken lightly, it's also, it's not all bad. There is a business opportunity here. And I don't mean to sound subservient by saying that, but there really has been kind of a, over the years, there's a kind of trepidation or fear that a lot of customers have about sharing their data. And they know they need to share it anyway. You can't, to use your Amazon example, you can't buy stuff from Amazon without sharing some data with them. And in modern life, that's almost required. So people do it, but they may feel really kind of insecure about it. And that creates a bad kind of relationship between the customer and the company. So there really is an advantage here, not just in mere compliance, but maybe for certain companies and certain facets of the law, even exceeding what's absolutely required by GDPR as a competitive advantage. Because if the higher degree of trust you can have with your customers, arguably the more business you're going to do with them. And by the way, if you have their consent, and consent's a big important thing here, if you have consent from your customers rather than just kind of assuming the consent without any explicit granting of it, but if you have explicit granting of consent, you can probably go forward and do a lot more analytics with a lot more confidence because you're kind of in the clear. Does that resonate with you, Tibi? Are
Yes,
your clients seeing it that way?
Yes,
or am I being naive?
In a way, I think you are naive, and I will tell you why. I think it resonates a lot with what you were saying. The one thing that you should always be aware of is that only because the user gave you consent, it doesn't give you right in perpetuity. The consent can always be withdrawn. So, I can give you consent now and say, yes, I'm okay with you getting access to my private data. I'm okay with you to use that information in whatever you seem necessary to do, even coming with, using my data for mining. I don't mind. But then it might come a day when I would say, you know what, I don't want you to do that anymore. And at that point, you have to stop. I don't say to you, you have to forget about me. I'm just saying you don't have my consent anymore. So whenever you start designing your applications, and that's one of the things that sometimes might feel a little bit scary. You need to make sure that you can get other solutions, legal solutions, to actually do the same kind of thing that you want to do. Maybe you can just anonymize the data. So I got the data and I don't care who you are anymore. I will remove everything about you, but I'm just keeping some of the things for historical reason, for statistical analysis, and something like that. So that's but again, those are stuff that we need to look into and make sure that we understand exactly how those should work. So that's why I say it's a little bit naive, because the consent can actually be withdrawn at any time, and at that point you need to make sure that either you give up the data or you apply, or you work with the data in a different way that is not, that makes you not breaking the law.
And thank you for making that distinction. I didn't mean to imply that once you have consent, you're home free, and suddenly the responsibilities melt away. That's absolutely not the case. But while you have consent, you're in a good place. And the very fact that consent at the level of particular customers or particular data subjects might be withdrawn only reinforces this idea that the data discovery is super important. Because when that consent changes, you're going to have propagation throughout different systems and different databases and data warehouses and data lakes where, that change in what we're allowed to do with the data and what we're allowed to leave there needs to be acted upon pretty quickly. So just to kind of finish sketching out what's in this slide. So we've talked about data protection officer. That's at the company level. Then we move up in the hierarchy to the country level, and that's where the data protection authority or authorities come into place. Each country will have one of these, potentially more than one, but I suppose the template, the typical case would be a data protection authority within the country. And because member states do have sovereignty, it is at least technically possible that the DPAs may have even more stringent regulations within the context of their borders. Although in previous discussion with you, I think you were saying that in practice that's not really happening, that GDPR, because it is that kind of striving for uniformity, that a lot of countries are kind of keeping to that and not exceeding it and not making things more complex. Do I remember that correctly?
Yes, and one of the things it's actually that the GDPR would actually supersede all the local laws, so they would actually become they won't be valid anymore. They'll become invalid after 25th of May. But like you said at the beginning, that doesn't stop any country to actually impose more stringent laws on that. Or like other countries, they can choose to leave the European Union just to not follow the GDPR. So it's still it's an option.
Sure, and I wonder, since you were stationed in the UK for a while, you were based in London, I guess.
Yeah.
Do you have a sense of whether the UK will end up kind of participating in GDPR's regulations, or is that still a bit up in the air as negotiations take place?
So if you think about it at the moment, so they're what one of the discussions is that they want to follow in the in the footstep of Switzerland and Norway, and Norway
Right.
and Switzerland are actually part of GDPR as well. So as long as you are doing you're doing any any business with all those countries, that's not a problem. But
Okay.
if you want to go
And sorry,
outside,
just for our audience that may not be super EU fluent, Switzerland and Norway are not actually part of the EU, but they are
no.
participating in the GDPR so that they're
Exactly. They are
compliant.
part of the EEA, the European Economic Agreement, actually. It is, which,
Okay.
more or less includes Switzerland and Norway, but not at the same level. They don't have to follow the laws. They have, they have the right of free movement and all the things that are. And there are some other countries, for instance, like Canada, Faroe Islands, Jersey, Isle of Man, New Zealand, that are actually still, they have an adequate. It's considered to have an adequate level of protection. So as long as you deal with those countries, you would have to you are considered safe. If you want to deal with U.S., actually, there is something called the EU-U.S. Privacy Shield, which is a certification, that imposes some levels of privacy that a U.S. company or a EU company at the end of the day needs to apply when it deals with data subjects from the other side of the pond, I would say. By the look of it today, UK actually it's meeting the adequate level of protection. That's given that if they're not changing their current regulation. But if they change it and relax it more, they might not be adequate anymore. But by how it looks today, they are adequate to be included or to be considered safe partners.
Yeah. So, and this gets confusing for those of us on this side of the ocean, that there's kind of concentric circles here. I mean, there are the member states of the EU. I suppose within that there's the zone for the the unified currency, the eurozone. So there are member states that are not actually using the euro, but they're still member states. And then beyond the EU, there are countries, geographically in Europe that are not part of the EU, but they still have standards and an affiliation such that they're, for all intents and purposes, part of GDPR. And you mentioned both Switzerland and Norway. Number one, you mentioned that the UK is judged to have adequate protection. So in effect, they're part of it. Of course, the EU is still the UK is still part of the EU, but they will be withdrawing. And then I guess you mentioned there's even kind of reciprocal agreements between the United States and the European Union that that provide the companies in the U.S. with some level of compliance. But then again, we know that we have higher standards to step up to than had really governed us before. So we've talked about the company level, we've talked about the country level, and then at the EU level itself, there is this thing all the way on the right of this slide called the European Data Protection Board, or the EDPB. And that is a board made up of the heads of each of the data protection authorities from each of the countries. And their job is to make sure that GDPR is applied consistently across the EU. Is there more to it than that?
No, you put that in there, that actually the DPA heads from the country, at the country level, are the ones that are that are part of the the European Data Protection Board.
All right. So that board is going to end up having quite a lot of importance and power, but exactly how they act has yet to be seen. I would think that for a smaller company, you'd probably want to watch very carefully to see how the EDPB works with much larger companies, to see kind of where the standards are going to be set, de facto standards versus de jure standards. All right, now let's talk about what what the subject of this webinar is actually about, which is how European companies are approaching compliance. And well, one point we'll get across here pretty quickly is that a lot of countries, I mean, as you said, maybe the regulations were not 100% consistent from country to country, but there were already a lot of standards in place in various countries. So if you're coming from a country that already had regulations and you met them, then you're probably feeling pretty ready for GDPR. There may have been some tweaks. There may have, some of those tweaks may just have been in terms of the language, but maybe in terms of practical matters, nothing changed. In other cases, I suppose there would be some practical changes as well, but in general, companies that have operated inside of companies that have already had pretty stringent data protection regulations, they're in a good place. Companies that, on the other hand, are coming from an environment where things were a lot more permissive, they've got a much bigger kind of readiness effort ahead of them. So I'm gathering then that your larger clients that are in Europe, they're probably not too nervous about this. They probably went through a lot of the growth and growing pains that they had to already. Is that right?
That is correct. Although they still have to make sure that they are still they are still following. It's not like once you did it, it's a done deal and you don't need to worry about it anymore.
Right.
It's continuously, because the nature of any business, it's to evolve, and that evolution means that you would always change the way you work with data, and changing that or improving onto that means that at some point you would actually need different kind of data with different different levels of sensitivity, or so again you need to always consider those kind of things, and need to make be aware of data breaches, need to make sure that you are protected. The law mentioned that you need to use state-of-the-art technology, but that doesn't say anything. It can be anything can be state-of-the-art technology. It's just about context at the end of the day, how you want to how you want to look at it. So
yeah,
that's what
I kind of think of this like when you're kind of looking at your own health and your own weight. I don't mean you. I mean one.
Generally, yes, yeah.
You can go on a diet and have a one-off weight loss, but it's fairly common knowledge now that that's not really effective, and what's most effective is kind of changing your diet permanently, changing the way you eat, changing the way you think about food. And so maybe this is kind of the equivalent for data. This isn't about going on a a data permissiveness diet and kind of getting compliant as a one-off. This is rather about kind of changing your way of life with respect to data. You're going to have to first of all, you're going to have to establish compliance, but second of all, you're going to have to monitor things and keep things in compliance. That's not a passive kind of activity. And this this is new, and it's new and it's permanent, right? This is not going to go away. So this is a big change for a lot of companies. I imagine it's also a change. I've talked about this in other venues. This also must be a change for individual developers and database specialists, that they have to change their way of thinking. Almost like, when we went through, especially those of us in the Microsoft sphere, if you look back 10 or 15 years ago, we went through kind of a cultural change around how we thought about security and making our code secure by default. Now we're talking about making things private by default, right? Or consent-driven by default. Is that right? Do you think individual developer teams? I mean, you're a tech lead. Are you kind of having to have that? I don't know, cultural education for the developers on your team? What's that like?
Yeah, so I think, I think at some point you would need to have the talk with the developers, because some of the things that might feel obvious for various reasons, that yes, we do it this way and yes, we do it that way, they might not see it, they might not understand. So that's why I think it's important so that they are made aware of the actually of the bigger picture and why they need to do that. Because without exaggerating, I think more than 80% of the developers have no idea what GDPR is. It's like I don't think it, because it feels like, it's a law, it's something, it doesn't concern us at all, which in practice actually does concern them. So like with all the things that that have to do with the IT industry, we need to make sure that the information is communicated right, from the upper level, upper management down to the to the people in trenches that are doing the job. And I feel personally, that it is my responsibility to actually, whenever I have a customer that deals with European data subjects, let me call them, in accordance to the law, that we are thinking about how we handle this kind of data. But if you are in companies in the US, that it's actually the laws are a little bit more more relaxed with regards to that. So a lot of times you don't even think about it. You just go and do the things that needs to be done, and then you take into consideration some other things, like you don't want to annoy the customer, but it's not illegal. It's just a business best practice, I would say.
Sure. I mean, it does sound like I start thinking about Y2K a little bit here. Everything had to be ready by that date. I don't think this is going to be a Y2K style thing where it's going to happen at the deadline. But it does seem like when the deadline hits, then at least taking everything very seriously will begin, and that we'll start to see the cultural change take place. I'm sure the regulators would prefer it that, since they announced this regulation and since they announced the deadline for it to come into force, that people would work to have readiness by that date. But no matter what, whether it's just before that date or just after it, people are going to start really having to work on this, and it's going to have to go down, I think, to the developer level for it to be real. And it's and it's not just about mitigating and remediating existing applications. It's about thinking about it as you write brand new code for greenfield applications. You're going to have to really internalize this whole idea. The good news is, if developers start doing that, then the ethical kind of handling of data becomes something much more feasible than otherwise. It just kind of felt like this big, amorphous, scary, insurmountable task. But the obligation for everybody to really pay attention to it, I think, will probably bring it down to earth in terms of feasibility. We've got about 9 minutes to go here. And here is where I guess, the elephant in the room comes out. We've alluded to a bunch of these things already. But there are ambiguities in this regulation. There is a decent amount left to interpretation. Number one, we already talked about how there is not sort of an authoritative compliance certification, that a lot of this is driven by self-assessment, and there's a lot of trust required in the case of multi-party relationships. What is specific is, the penalties for non-compliance. The actual requirements that are crystal clear maybe are not always there. And the self-assessment, you spoke to this about. You spoke about this previously. So that's tricky, right? I mean, that's just hard to kind of make peace with this idea that I can't tell you exactly what you need to do, but I can tell you you're going to get in trouble if you don't do it.
Yeah.
You have to suspend disbelief a little bit there. How are your customers sort of facing that?
Yeah, and one thing actually I wanted to give an example a little bit earlier. It's more or less the same with
Sure.
licensing, So when you want to run something, it's your responsibility to have the proper license. Some companies, they enforce you to actually connect to a server and report a license and stuff like that. But most companies, they do not do that. But if you get an audit and someone comes and check your licenses and you are not complying, you would have to pay not as hefty as for not complying with GDPR, but you might have to pay some money. While here, when it comes to GDPR, you might actually get, you might get in trouble because some people are making complaints. Some like you are not removing their personal data, or you're not doing that, and it would be a little bit more stringent. But again, it's up to you to make sure that you're doing the right thing sooner than later, I would say.
Right. And so, again, I think it's probably a matter of being proactive, right? You've got to
Yes.
You've got to put that best effort in. And I imagine, and not that I know, not that I'm an ultimate authority here, but I imagine the regulators are going to look at that kind of effort and dedication pretty carefully. That companies that seem lax and unresponsive are probably going to be held in lower regard than those that have really been trying their best. And I can't swear to it, but I imagine there's going to be greater I don't want to say forgiveness, but understanding in the case of ambiguities for companies that have exhibited a best effort.
Yeah.
And again, perhaps this was naive, I don't know, but it does make sense to say, look, this is in my interest too, not just so I'm compliant with the law, but because I'm going to have a better relationship with my customers if I'm transparent about what I'm doing with their data and if I give them control back in terms of their own data. And the privacy by design, we kind of just talked about that. That's really the notion that developers will have to be thinking about this as a design point. Architects especially will have to think about this as a design point when new applications and databases are designed and built. Can we talk about the cloud for a minute before we say goodbye?
Of course.
I mean, my own kind of amateur observation is that the big public cloud providers like Amazon Web Services and Microsoft Azure and I guess IBM and Google as well, they have been on a mission to achieve GDPR compliance for quite some time. And I'm thinking that they now feel that they have that compliance. Does that now actually mean that I reduce my risk by putting stuff on these public clouds versus physically managing the infrastructure myself and having systems run on premises? And is that driving cloud adoption? Go ahead.
Risk, yes. Responsibility, no. I mean, you're still responsible for doing the right thing, regardless of, if Microsoft says, yes, we do exactly what you ask us, all the data is encrypted, we don't own the data, you don't own the data, you can have the, data encrypted at rest, any password and whatever. So, everything aligns with what the GDPR asks. So them as data processors are actually doing the right job. So they are compliant. So you can actually you can breathe easily from that point of view. But when it comes to your own responsibility and what you're doing with your own applications, that's a different story. Because if you do collect the data, private data, and you save it on Azure, it's not Microsoft's fault that you save data against the user's consent. It's still your application. It's still what you have done, and not what Microsoft was doing with your data.
So there's sort of a ring zero assurance that you get maybe by being on the cloud. But rings 1, 2, 3, and 4, they're still up to you. And by putting stuff on the cloud, you may reduce risk, but you do not abdicate responsibility at all. So the vigilance is still required. Maybe the confidence can be somewhat raised. And do you see that driving adoption, or do you think kind of cloud adoption is its own phenomenon and things are headed there anyway? So this is more.
I think it will help. It will accelerate even more because I don't know. I feel like a broken record, because for the past 3 years I said this would be the year of the cloud, and every year it's actually exceeding my expectation. But it's still not there yet. I would say, we are still. I mean, it's still the cloud. It's still seen as as a second-hand citizen for many companies, and they are still look at it, and they're a little bit afraid. But now with all those kind of things, I think it makes a lot of sense. If you look at all those, if you look at GDPR and all the compliances that you might be in a different industry, and they do have a lot of compliances and they do comply with a lot of regulations. I think that will make your life easier as a business to actually have to worry less about infrastructure and hardware and worry more about how you do the stuff.
Makes sense. And I will also just mention, although I alluded to it at the beginning, that Io-Tahoe's product specializes in the kind of data discovery we were talking about in terms of mapping relationships within databases, mapping flows between databases and warehouses and lakes. And we have specific components for detecting sensitive data, which is what GDPR is all about, and also detecting redundant data. And then even being able to do data flow around those things specifically. So that's our interest in this topic. We hope that's part of the reason why Gartner bestowed upon us the cool vendor distinction at the end of April of last year. But that's how all this comes into play. And we're at the top of the hour now. So Tibi, I want to thank you. You helped us get out of the North American echo chamber here and actually bring a European.
Thank you for having me, Andrew.
Thank you. It was nice to have a European participate in a discussion about something that's European. And I want to thank everyone who tuned in. The recording will be made available and put up on our YouTube channel before very long. Tibi, that may be germane to you as well. But at this point, thanks again, Tibi. Thanks again to the audience, and I'll wish everyone a good morning, afternoon, or evening, depending on their location. Thanks, everyone.
Thank you very much. Bye.
Bye-bye.